This is the brief on the fundamental standards of international criminal culpability. Today we're diving into the International Criminal Court's Elements of Crimes, a foundational rulebook that helps the court interpret its core statutes on genocide, crimes against humanity, and war crimes, Article 6, 7, and 8, to figure out exactly what it takes to hold someone legally responsible on the global stage. First, let's look at the mental element. To actually face punishment, a person must commit the physical acts of a crime with both intent and knowledge. But here's the kicker. The court isn't just waiting around for a taped confession. They can simply infer your intent and knowledge straight from the surrounding facts and circumstances of the event. Second, consider those highly subjective value judgments. What really makes a crime inhumane or severe? Well, simply put, the perpetrator doesn't actually need to have personally recognized or judged their own actions as inhumane to be held fully responsible for them. Finally, the structure of these rules is incredibly deliberate, systematically organizing elements by looking at conduct, then consequences, and then circumstances. And, in a really fascinating quirk, the legal text uses the word perpetrator completely neutrally, making absolutely zero assumptions about a person's actual guilt or innocence. Ultimately, these structural elements strip away the guesswork, providing a precise, fact-based framework for evaluating intent, conduct, and ultimate responsibility in international law.
So how do you prove guilt for some of the worst crimes imaginable? Today, we're going to go inside the official rulebook of the International Criminal Court. Yeah, we're looking at the very document that sets the standard for justice on a global scale. I mean, really think about that for a second. When you're talking about crimes on a massive scale, genocide, war crimes, the evidence is almost never simple. You're not going to find a single smoking gun. So how does a court possibly establish who's culpable for acts that can involve thousands of people and span entire countries? Well, it's definitely not guesswork. The ICC actually relies on a highly structured, super methodical framework. You can think of it as a blueprint for justice, one that's designed to bring clarity to absolute chaos. And today, we're going to break down exactly how it all works. First up, let's talk about that blueprint. To really get how the court operates, you have to start with its core document. And listen, this isn't just some dusty set of guidelines. It is the very foundation for every single decision the court makes when it's looking at a crime. It's a document called the Elements of Crimes. And honestly, the best way to think about it is like the court's official instruction manual. Now, it's not the law itself, but it's the essential guide that helps judges interpret and apply that law consistently, every single time. And its whole purpose is crystal clear: consistency. This systematic process is a huge deal because it's designed to be the exact opposite of so-called victor's justice, where the winners of a war just punish the losers. Instead, whether it's a case about genocide or a war crime, this document provides the same standard for everyone. It makes sure justice is methodical and fair, not just arbitrary. Okay, now for what is arguably the most important concept in this entire framework. We're talking about the criminal mindset. Because you see, it's not just about what happened. It's about what was going on in the mind of the person accused. This quote right here gets to the heart of the matter. It's from the Rome Statute. That's the founding treaty that created the ICC. And it sets the default standard for every crime. Guilt requires two things: intent and knowledge. So what does that actually mean in practice? Well, this slide shows the huge difference. On one side, you've got a planned act. The person intended for the outcome to happen, and they knew the criminal context of their actions. But on the other side, you've got an accident or just unknowing involvement. The physical action might even look the same, but that mental state is what separates a tragedy from a crime in the eyes of the court. But wait, how do you prove what someone was thinking? I mean, the court doesn't rely on mind reading, and it certainly can't just hope for a confession. So the crucial point here is that this mental element can be inferred from the evidence, from a pattern of behavior, from emails, from all the circumstances surrounding the act. The facts, they tell the story of the mindset. So, once that mental element is on the table, how does the framework actually analyze the crime itself? Well, it breaks it down into 3 core building blocks to construct a full picture of what happened. You can think of it like a 3-part recipe. First, you have the conduct. What did the person physically do, or in some cases, what did they fail to do? Second, the consequence. What was the direct outcome of that action? And third, the circumstance. What was the wider context, like was there an ongoing war, that frames the entire event? And as you can see here, the order is absolutely deliberate. The court always starts with the concrete action, then moves to the result, and only then does it zoom out to look at the context.
This methodical process prevents judges from, say, jumping to conclusions based on the situation before the specific act has even been established.
Now, this is really interesting. Just as important as what's in this blueprint is what's intentionally left out. The document is incredibly precise, and a lot of its power comes from its intense focus.
For example, the framework doesn't get into the perpetrator's personal feelings. Whether they felt their actions were inhumane is totally irrelevant to this part of the analysis. It also doesn't cover legal defenses, like insanity or duress, because those are handled completely separately. And it intentionally avoids vague ideas like unlawfulness, just to stay laser-focused on the specific crime.
So why leave all that out? It's all about keeping the analysis razor-sharp and objective. The goal is to avoid getting bogged down in subjective arguments or legal rabbit holes. It forces the court to focus squarely on the core facts, the conduct, the consequence, and the circumstance. Period. Okay, let's pull all these threads together. Why is a document like this so incredibly critical for global justice? Why does this whole framework matter so much? Well, it all boils down to these core principles. First, neutrality. The language is very precise. Even when it uses the word perpetrator, it's just a placeholder, not an assumption of guilt. Second, versatility. The framework gets that one single act can actually break multiple laws at once. And, maybe most importantly, universal application. These standards apply to absolutely everyone equally, from the lowest-ranking soldier all the way up to a head of state. And that's essential for the court's legitimacy. And that really brings us to the ultimate point here. This structured approach provides a universal standard. It's what transforms the noble idea of international justice into a real, functioning system, one that is systematic and predictable, not arbitrary. This, right here, is the bedrock of the court's authority. So, if you remember anything from our deep dive today, let it be these three things. First, it's all about intent. That criminal mindset is the absolute key. Second, remember that three-part recipe: conduct, consequence, and circumstance. And finally, its real power lies in its intense focus, in its ability to cut through all the noise to get to the core facts of a case. And all of this leaves us with a final and pretty tough question. By creating a single, universal standard to judge humanity's worst crimes, does it actually make the pursuit of justice simpler and fairer? Or does applying one single blueprint to the world's incredible diversity of conflicts make it even more complicated? It's definitely something to think about. Thanks for tuning in.
Okay, let's unpack this. We live in a world that is absolutely flooded with information.
Constantly.
We scroll through our feeds and we see headlines that they stop us in our tracks. We see reports about international justice, about the International Criminal Court, the ICC.
Right.
And you see these massive, terrifying terms thrown around: war crimes, crimes against humanity, genocide. And usually, for most of us, the engagement it just stops right there.
It stops at the emotional impact. It has to.
Exactly. We see the photo, we read the headline, we feel that pit in our stomach, and we think, that is evil. And then we keep scrolling.
It's the natural human reaction. I mean, what else can you do? You react to the horror of the event itself. You process it emotionally.
Exactly. But today we are going to do something very different. We're going to stop scrolling. We are going to sort of pause the emotional reaction for a second, and we are going underneath the headline.
Into the weeds.
We are going deep into the engine room of international justice. We aren't looking at a specific trial or a specific warlord or a specific battlefield today. We are looking at the rule book itself.
The machinery.
The source material we have in front of us is titled Fundamental Standards of International Criminal Culpability, but specifically, we are doing a deep dive into the general introduction to the ICC elements of crimes.
And I know you're thinking, I can hear the listeners right now.
Oh, I know.
General introduction to the elements of crimes. That sounds like the driest, most bureaucratic, most dusty legal document imaginable.
It does.
It sounds like the terms and conditions you click agree on without reading just to get to the app.
I will admit, when I first opened the file, that was my exact thought. I saw the formatting, I saw the paragraph numbers, and I thought, oh boy, we are in for a lecture.
Yeah.
But, and this is that would be a massive mistake.
A huge mistake, because once you start reading, you realize this isn't just paperwork. This is not just bureaucratic red tape.
No, absolutely not.
It is the blueprint.
It is the blueprint for how justice is measured on the global stage. It's the operating system for holding the worst people in the world accountable.
Precisely. If you imagine the Rome Statute the treaty that established the ICC as the Constitution, right? The broad, sweeping law that says we stand for these values.
The big ideas.
The big ideas. Then this document, the Elements of Crimes, is the operating manual. It is the interpretive guide for Articles 6, 7, and 8 of the statute.
And just to orient everyone, because we assume people know these terms, but maybe haven't, memorized the articles. Article 6 covers genocide.
Right.
Article 7 is crimes against humanity.
Right.
And Article 8 is war crimes. The big three.
Correct. But here is the catch, and this is the important part. The statute just lists them. It says genocide is X. It defines the crime in a broad sense. The Elements of Crimes document tells the judges, the prosecutors, and the defense attorneys. Here is exactly, step by step, bullet point by bullet point, what you need to prove to make that charge stick.
So that's the central question we're framing today. When the ICC looks at a horrific event, a mass atrocity, how do they actually break it down? How do they turn something terrible happened into a provable legal fact?
Yeah.
Because it's not enough to just say that was evil. You have to prove it fits a very specific, almost mechanical structure.
And that is the gap this document fills. It bridges the gap between the chaotic, messy, heartbreaking reality of human suffering and the rigid, logical requirements of the law.
So we're looking at the rules of the game.
Exactly. How intent is proven, how crimes are structured, and who actually counts as a perpetrator. It's all in here.
And I have to say, my initial impression reading through this source material, I was surprised by how mechanical it is.
It's cold, isn't it?
It feels like a technical manual for something that is inherently emotional. You read about conduct and consequences and circumstances, and you have to keep reminding yourself, we're talking about some of the worst things human beings can do to one another. It felt a bit like reading a repair manual for a car engine, except the engine is, well, genocide.
That cognitive dissonance you are feeling is real. I felt it too. But that structure is necessary. It might feel cold, but without that rigid structure, the application of the law would be chaotic.
You'd be arbitrary.
It would be totally arbitrary. You cannot prosecute based on vibes or general feelings of outrage. And look, paragraph 1 of our source material explicitly links this to Article 9 of the statute. It's about ensuring fairness.
Right.
If you don't define the elements clearly, you risk punishing people based on ambiguity. And in international law, where the stakes are life imprisonment, ambiguity is the enemy of justice.
So our mission today is to decode that mechanical structure. We're going to look at the framework, the mental element, which is fascinating, by the way,
Oh, it's the core of it.
and the specific technical traps that exist in the text. We're going to take this apart piece by piece to see how the machine works.
It is a journey into the anatomy of a crime. Let's do it.
All right, let's dive into section 1, the framework. We're looking at paragraph 1 and paragraph 7 of the source, and paragraph 1 starts right off the bat by saying, the following elements of crimes shall assist the court in the interpretation and application of Articles 6, 7, and 8.
Let's pause on that word.
Assist.
Assist, yeah. That word is doing a lot of work there.
It is. It stood out to me right away. It doesn't say govern. It doesn't say dictate or define. It says assist. So why is that distinction so important? Is this document not? Is it not binding law?
Oh, it is law, but it is a specific kind of law. It's all about hierarchy. The statute, the Rome Statute, that is the supreme law here.
Yeah.
The elements of crimes are subservient to the statute.
So they're a tool.
They are a tool. They are there to help the judges interpret the statute, but they can never, ever contradict it. And paragraph 1 makes this crystal clear by saying the application must be consistent with the statute.
So if there's a conflict, if the main treaty says one thing and this document says another, the treaty wins. No question.
Exactly. The statute is the Constitution. This document is the regulation manual. And it's not operating in a void either. Paragraph 1 also mentions that Article 21 and the general principles set out in Part 3 of the statute are applicable here.
So it's weaving itself into the broader legal fabric.
It's saying, don't read this in a vacuum. This is part of a larger system. You have to read it all together.
I really like that analogy of a constitution versus a regulation manual. The Constitution sets the big rights and the broad strokes. The manual tells the inspector on the ground exactly what to measure, what to look for.
That is a very apt analogy. The statute says, thou shalt not commit murder as a war crime. The Elements of Crimes says to prove murder as a war crime, you must check box A, check box B, and check box C.
And checking those boxes isn't random. This leads us right to paragraph 7, which I've found really helpful for visualizing this whole thing. It breaks down the architecture of a crime. It says the elements are generally structured in a specific order.
Yes. paragraph 7A. It outlines what I like to call the holy trinity of international criminal law: conduct, consequences, and circumstances.
Okay, let's break those down.
Yeah.
Because to a layperson, a crime is just the crime. It's one big blob of a bad action.
It's a single event.
Right. He killed those people. But this document says, no, you have to slice it up. You have to categorize the parts of that blob.
You do. You have to. Think of it as dissecting a biological specimen. You have separate organs that function together to create the organism of the crime. First, you have conduct.
The act itself.
The verb.
The physical act. Pulling the trigger, signing the order, driving the deportation truck. Without conduct, there is no crime. You cannot be punished for thoughts alone.
Which is a pretty fundamental legal principle.
It is. The law doesn't police your internal monologue. It polices your interaction with the world, your actions.
Okay, so conduct is the doing. That seems straightforward enough. Then comes consequences. The result of that conduct, the outcome. If the conduct is firing a missile, the consequence might be death of civilians or destruction of property.
So there has to be a link.
There has to be a causal link. In many crimes, you must prove that the conduct actually caused a specific result. You have to draw a straight line from the act to the outcome. It can't just be a coincidence.
Got it. And then the third one, which I think is often the most complex in international law, and the one that really separates the ICC from, your local courthouse.
Yeah.
Circumstances.
The contextual circumstances. This is what makes international law unique. This is the whole ball game, really.
Okay, so let's unpack this with an example. If I commit a murder.
Let's say you commit a murder in a quiet suburban town on a Tuesday.
Okay. Terrible, but domestic.
Right. That is a domestic crime. The police come, you go to a regular court, the conduct is shooting, the consequence is death. But for it to be a war crime, there is a circumstance required.
And that circumstance is?
It must take place in the context of an armed conflict.
So the circumstance is the container that the act sits inside.
Exactly. Or, for a crime against humanity, the circumstance is that it's part of a widespread or systematic attack against a civilian population. The act murder might be exactly the same physically. The bullet flies in the same way. But the circumstance elevates it to an international crime.
That's a huge distinction. And paragraph 7C notes that these contextual circumstances are generally listed last. Why last? Is there a reason for that?
I think it's about the narrative flow. It frames the picture. Think of it like a camera lens. You zoom in on the act, conduct, the finger on the trigger.
The micro level.
The micro. Then you pull back to see the result, consequence, the person falling. And then you zoom way out to see the situation, circumstance, the battlefield, the systematic attack, the broader context. It places the specific act within the broader picture.
That makes so much sense. It's a logical flow from the specific to the general, from the micro to the macro.
It is. And there is one more little nuance in paragraph 7B regarding the mental element placement that's worth touching on.
Oh, right. I saw that. It says, when required, a particular mental element is listed after the affected conduct, consequence, or circumstance. That sounds a little jargony.
It is, but it's a really smart drafting technique. It connects the specific intent to the specific part of the crime.
So it's about precision.
All about precision. For example, if you need to know that the person you are killing is a protected person, like a prisoner of war or medic, the requirement for knowledge of that fact would be listed right after that circumstance. It ties the mind to the fact. It prevents a defense of, oh, I shot him, but I didn't realize he was a medic.
It forces the prosecution to prove what the person knew about each specific element.
Exactly, which is a perfect segue, actually, because we've talked about the physical structure, the body of the crime.
Right.
But now we need to talk about the soul of the crime, the mind,
The mens rea.
the mental element.
This is section 2, inside the mind. This draws from paragraphs 2 and 3 of our source. And this is where it gets really, really interesting for me. Paragraph 2 references Article 30. It calls it the default rule.
This is the golden rule of ICC culpability. It's so fundamental. Paragraph 2 states, unless otherwise provided, a person shall be criminally responsible only if the material elements are committed with intent and knowledge.
Intent and knowledge, those are the two pillars.
Those are the pillars. And the source explicitly says that where the elements of crimes document is silent, where it doesn't mention a mental state at all, it is understood that Article 30 applies.
So if I'm a lawyer reading the elements for a specific war crime and it doesn't say anything about what the guy was thinking,
Then you know.
I have to assume the prosecutor needs to prove intent and knowledge.
Correct. It is the default setting. If the text is silent, you assume Article 30 is the standard. You revert to the default.
Let's deep dive on that. What did that actually mean for the prosecution? Intent and knowledge. How high of a bar is that?
It sets a very high bar. Intent generally means you meant to engage in the conduct, and for some crimes, you meant to cause the consequence. You didn't just accidentally bump into the button that launched the missile. You intended to launch it, and you intended for it to blow up that target. It implies volition, a conscious choice.
And knowledge. How is that different from intent?
Knowledge usually relates to the circumstances. You knew there was an armed conflict going on. You knew the person you were targeting was a civilian and not a soldier.
You were aware of the facts on the ground?
You were aware of the factual landscape in which you were acting. It prevents accidental criminality. You cannot, generally speaking, stumble into a war crime by mistake under the Article 30 standard.
But the text says, unless otherwise provided. That phrase keeps popping up.
It's a crucial phrase. Paragraph 2 notes that exceptions to Article 30 are indicated in the text or based on the statute.
So they can lower the bar if they want to.
Or change the nature of the bar. For example, in some command responsibility cases, the standard might be something closer to recklessness or what a commander should have known.
A negligence standard.
Something like that. But the key takeaway here is the precision of it all. If the drafters wanted a standard other than intent and knowledge, they had to explicitly write it down.
They had to opt out of the default.
Exactly. If they didn't write it down, it's intent and knowledge or bust. No wiggle room.
It protects the accused, really. It ensures you aren't convicted for being careless when the law usually requires a specific malicious intent.
Precisely. It upholds the principle of personal culpability. You are punished for your choice to do evil, not just for your failure to prevent it, unless the law specifically and explicitly says otherwise.
Okay, but here is the problem. And this is something I always wonder about when watching these trials or reading about them. We're talking about intent. We are talking about knowledge. We are talking about what is happening inside a human brain.
The black box.
The black box.
Yeah.
You can't drill into someone's head and pull out a thought bubble that says, I intend to destroy this village. It's impossible. So how do you prove it?
Well, the drafters knew this was the central problem. And paragraph 3 of our source addresses this directly. It says, existence of intent and knowledge can be inferred from relevant facts and circumstances.
Okay.
This is the proving the unprovable clause. And practically speaking, in the day-to-day work of the court, it is the most important tool the judges and prosecutors have.
Inferred. That's the key word. So you're not proving it directly.
You're proving it indirectly. It means you do not need a confession. You do not need a diary entry where the defendant writes, "Dear diary, today I have decided to commit genocide."
Which, let's be honest, rarely happens. People aren't usually that helpful to the prosecution.
Exactly. Perpetrators of mass crimes usually try to hide their intent. They use euphemisms, they destroy records, they claim it was an accident or a misunderstanding or collateral damage. So paragraph 3 allows the court to look at the external world to understand the internal world.
Can we visualize this? How does inference work in a real courtroom setting? Give me an example.
Of course. Imagine a scene. A commander is on trial. He claims, "I didn't know my troops were targeting civilians in that village. I thought they were fighting insurgents. I had no intent to kill innocents." That is his claim about what was in his mind.
Okay. His defense.
But the prosecutor brings in the relevant facts and circumstances as allowed by paragraph 3. Fact 1. Reconnaissance photos show the village had no military targets, no tanks, no barracks, just houses and a school.
Okay.
Fact 2, the troops that went in used machetes and small arms, not long-range weapons, implying close personal contact. Fact 3, the commander received radio reports every hour detailing the body count, and those reports specifically listed the number of women and children killed.
I see where this is going.
The court takes those facts and asks a simple question. Could our rational person in that situation with that information not have known what was happening? And the answer is no.
It defies logic.
It defies logic. Therefore, we infer knowledge. We deduce that he must have known because the facts make any other conclusion impossible. His claim of ignorance is just not credible.
So actions really do speak for the mind in this context. You build a puzzle of intent out of the pieces of conduct.
That's a great way to put it. It allows justice to function in the real world. If we required absolute direct proof of what was in a neuron at a specific moment in time, no one would ever be convicted of these crimes.
Right.
Paragraph 3 bridges that gap between the unknowable mind and the undeniable facts.
That is fascinating. It's like Sherlock Holmes stuff. Deductive reasoning becomes a formal legal standard.
It is the only way international criminal law can survive. It has to have a mechanism to deal with reality.
Now, speaking of the mind and what people think, this brings us to Section 3. And honestly, this was the biggest aha moment for me in this entire document. I had to read it a couple of times.
The value judgment trap.
Yes. Paragraph 4. It deals with words like inhumane or severe. These are subjective words, right? They're loaded. What I think is severe, you might think is mild. What I think is inhumane, a sadistic warlord might think is just a Tuesday.
Correct. These are evaluative terms. They require a judgment call. They aren't objective facts like the person is dead.
So paragraph 4 says, with respect to mental elements associated with elements involving value judgment, it is not necessary that the perpetrator personally completed a particular value judgment unless otherwise indicated.
That is a dense sentence, but the implication is absolutely massive.
Let me try to put this in a scenario to make sure I've got it right. Let's say a perpetrator is charged with inhumane acts. He treats his prisoners terribly, starves them, beats them daily.
A clear case, factually.
Right. But in his trial, he stands up and says, Your Honors, I admit I did those things. I admit I starved them and beat them, but I honestly didn't believe it was inhumane. In my culture or in my ideology, this is necessary discipline. I did not intend to be inhumane because I don't believe my actions were inhumane.
That is the defense of subjective morality. I didn't think it was wrong, therefore I didn't have the intent to do the wrong thing. It's a classic defense.
In paragraph 4, it just shuts that down completely.
Completely and utterly. Paragraph 4 says, it does not matter what you thought about the legal or moral label. It does not matter if you, in your heart of hearts, thought it was humane or inhumane. The question is, did you intend to do the act?
The conduct.
The conduct. Did you intend to starve them? Yes. Did you intend to beat them? Yes.
And then, what's the next act?
And then the court, the judges, decide if those acts meet the objective standard of inhumane as understood by international law. If the court says it is inhumane, you are guilty. Your personal agreement with the definition is irrelevant.
Wow. So you need intent for the conduct, the beating, but you don't need to share the value judgment, the inhumanity.
Precisely. You do not need to mentally check the box that says, I am being inhumane right now. You just need to knowingly commit the act that society, through the law, defines as inhumane.
Why is this so important? It feels like a really big deal.
Think about the alternative. Imagine if we required the perpetrator to personally agree that their actions were inhumane or severe.
The most dedicated fanatics would get off.
Exactly. The most fanatical, the most brainwashed, and the most twisted perpetrators would be the hardest to convict.
Because they truly believe they are doing the right thing. They see it as justice or purification.
Or anything else. The Nazi who believes Jews are subhuman wouldn't think his actions are inhumane in a moral sense. He'd think they were righteous. The terrorist who thinks he is saving the world wouldn't think his attack is severe in a negative way. Paragraph 4 prevents a perpetrator's warped morality from becoming a legal shield.
It imposes an objective reality. It says, we don't care what your personal philosophy is. There is a line. You crossed it.
It anchors the law in a shared humanity, not in the subjective mind of the criminal. Unless, again, it's otherwise indicated, the law relies on the fact of the severity, not the perpetrator's opinion of it.
That is powerful. It really stops you from getting bogged down in these endless, unwinnable philosophical arguments with a war criminal.
It keeps the focus on the suffering of the victim, which is where it belongs, rather than the philosophy of the perpetrator.
Okay, moving on to section 4. We've got some technicalities here, but they are important ones. They're the nuts and bolts. We're looking at paragraphs 5, 6, 8, 9, and 10. Let's start with paragraph 8 because it defines who we are even talking about.
The term perpetrator.
Right. The source says the term perpetrator is neutral as to guilt or innocence, which makes sense.
This is standard legal presumption of innocence. Just because the document calls someone a perpetrator in the abstract description of a crime, it doesn't mean the specific guy in the doc is guilty yet.
It's a placeholder.
It's a placeholder term. A variable, like x in an algebra problem. It applies to everyone whose responsibility falls under Articles 25 and 28.
But then it adds something crucial, a bit of Latin. It says the elements apply mutatis mutandis to all those whose criminal responsibility may fall under Articles 25 and 28 of the statute.
Mutatis mutandis, every lawyer's favorite fancy Latin phrase.
Means with the necessary changes, right?
Yes. It means adjusting for the details but keeping the main point. And this is vital because it broadens the net considerably. It's not just about the person on the ground. It references Article 25, individual criminal responsibility, and crucially, Article 28.
And Article 28 is command responsibility.
That's the one. The responsibility of commanders and other superiors. So this paragraph confirms that these elements of crimes don't just apply to the guy pulling the trigger.
The foot soldier.
Right. They apply to the general sitting in an air-conditioned office 10 miles away who gave the order or who failed to stop his troops. You just have to adjust the conduct element slightly to fit his role. His conduct might be the failure to supervise or issuing of the order, but the core definitions of the crimes remain the same.
It ensures that the definition of murder doesn't change just because you are a boss instead of a soldier. The crime is the crime.
Exactly. The core of the crime is constant.
Now, paragraph 9. A particular conduct may constitute one or more crimes.
This is the concept of multiplicity or cumulative charging.
I found this fascinating. At first, I thought it was about efficiency in charging, but it seems deeper than that.
It's not just efficiency, it's about accuracy. It's about reflecting the full criminality of an act. In international law, a single event can ripple out and violate different legal categories.
Can you give examples how that would work in practice?
Sure. Imagine a commander orders the bombing of a cultural center, a famous museum that he knows is sheltering civilians from a particular ethnic group he wants to drive out.
Okay, a horrific act.
A single order, one act of conduct. But that one order could be charged as 1, murder as a war crime for the civilians killed.
Right.
2, destruction of cultural property as a war crime. 3, intentionally directing attacks against a civilian population as a war crime. And 4, persecution as a crime against humanity because it targeted a specific ethnic group.
1 signature, 4 charges.
Because that one act violates 4 different protected interests under the law. Paragraph 9 clarifies that this is allowed. You don't have to pick just one. You can, and often should, charge them all if the elements fit.
That's fascinating. It reflects the true scale of the horror. It's not just you broke a building. It's you broke a building, killed people, tried to erase a culture, and terrorized a population.
Precisely. It captures the full spectrum of the criminality of that single decision.
Now, what about what's missing from this document? Paragraphs 5 and 6 seem to be about what is not in here.
Yes, and that's just as important as what is. Paragraph 6 deals with unlawfulness. It says the requirement of unlawfulness is generally not specified in the elements.
Why not? Don't you have to prove it was illegal? Seems like a basic part of a crime.
In domestic law, sometimes you do. You might have to prove a lack of consent in a theft case, for example. But here, the illegality is inherent. It's baked in.
You mean?
If you commit genocide, there is no version of it that is lawful. You don't need to prove this was illegal as a separate element. The illegality is inherent in the act itself. The document assumes it.
So it saves words and time. We assume genocide is bad. Got it.
And paragraph 5 talks about defenses, the grounds for excluding criminal responsibility. It says they are generally not listed here under the elements of the individual crimes.
So if I was acting in self-defense, or I was under duress, or I was a child soldier, I won't find those rules in the elements of crimes document.
No. This document is about the offense. The defense is found elsewhere in the statute, in Articles 31, 32, and 33. This document focuses purely on what the prosecutor needs to prove to make their case.
The building blocks of the charge.
Exactly. Not on what the defense can raise to excuse it.
That's a key distinction. Don't look for your way out in this document. Look for what got you in.
That's a very good way of putting it.
Finally, paragraph 10. This felt like a funny little detail to end the technical section. The use of short titles for the crimes has no legal effect.
This is a lawyer's precaution, a classic CYA clause.
It sounds like pure legal pedantry.
It is, but for a very good reason. We use short titles like murder or extermination or torture as shorthand. They're convenient, but the actual legal definition is the long, bullet-pointed list of elements we've been discussing.
So if the short title implies something that isn't in the detailed list or vice versa?
The list wins. Every time. The detailed description is the law. The catchy headline is just a label for the file folder.
So it prevents arguments like, well, the title says attack, but I didn't technically attack.
Precisely. If your conduct fits the elements of the crime as written, you are guilty, regardless of whether the short title feels like a perfect fit for what you did. In international law, accuracy is everything.
Okay, so we've covered a lot of ground here. We've gone from the broad framework to the deep psychology of intent, to the specific technical rules of how charges work.
It is a dense but very logical ecosystem.
Let's try to synthesize this deep dive. If we look back at the journey we just took, we started with the idea that this isn't just paperwork, it's the assist function, the guide to the statute.
And we saw the architecture in paragraph 7, conduct, consequence, circumstance. That structure is the skeleton, the absolute bedrock of every international crime.
We then looked inside the mind, at the mental element, in paragraph 2. The default rule is high: intent and knowledge. You have to mean it. But
paragraph 3 gives us the crucial inference tool. We can prove you meant it by looking at what you did. We don't need to read your mind. We read your actions and the context.
And we debunk the value judgment trap in paragraph 4. You don't have to agree that your actions are inhumane to be guilty of an inhumane act. The law sets the standard, not the perpetrator.
Which is such a critical point. And finally, we saw that perpetrator is a broad, neutral term that can capture everyone from the foot soldier to the general, and that one act can trigger a whole host of different crimes.
It really is a machine designed to process horror into justice.
That is a very evocative way to put it, and I think it's accurate. It strips away the emotion, not to be cold, but to ensure that the judgment is fair, consistent, and provable.
So, as we wrap up, what is the one thing, if the listener takes away just one thing from this entire discussion, what is the provocative thought they should leave with?
For me, it comes back to that value judgment rule in paragraph 4. I want the listener to really mull on that.
The idea that your personal morality doesn't matter.
Exactly. By saying that a perpetrator does not need to believe their actions are severe or inhumane to be liable, the ICC is effectively imposing an objective standard of humanity on the entire world.
Regardless of culture. Regardless of ideology.
Regardless of anything. It rejects moral relativism in the face of atrocity, it says. There is a line. There are things that are objectively inhumane, whether the person doing them sees it that way or not.
So your personal justifications they evaporate.
They mean nothing to the law. The document says that humanity has a baseline, and if you cross it, your personal justifications, I didn't think it was that bad, or my cause required it, mean absolutely nothing. It says there is a line, whether the perpetrator sees it or not.
That is a heavy, but I think a hopeful thought, that there is a universal baseline we can appeal to.
It is the foundation of international justice. Without it, the whole project would be impossible.
Well, on that note, we are going to sign off. Thank you for joining us on this exploration of the machinery of justice.
It was a pleasure to decode it with you.
And for everyone listening, next time you see a headline about a war crime trial, I want you to think about intent. Think about inference. Think about that invisible checklist that the lawyers are filling out behind the scenes. It changes how you see the news. Thanks for listening to The Deep Dive. Catch you next time.
Welcome to the debate. Today we are opening the hood on the International Criminal Court to look at the engine itself. We are talking about a specific trial, a specific warlord, or, a specific battlefield today. We are looking at the text that underscores all of it. The general introduction to the ICC's elements of crimes.
It sounds so dry when you say the title, doesn't it? General introduction. It sounds like the part of a book you just skip to get to the good stuff. But this document is effectively the source code for international justice. It is the interpretive guide that tells judges, prosecutors, and defense attorneys how to read Articles 6, 7, and 8 of the Rome Statute. That's genocide, crimes against humanity, and war crimes.
Exactly. It is the lens through which the court views the worst acts humanity can commit, and the stakes couldn't be higher. This text decides a really fundamental question. When a city is destroyed or a population is displaced, do we need to prove exactly what was in the general's mind, or do we just look at the rubble and say the destruction speaks for itself?
That really is the core tension. Is this document a shield that protects the accused by demanding we prove beyond any reasonable doubt that they intended every single specific outcome? Or is it a sword for the prosecution, designed to cut through excuses and, infer guilt from the chaos of war?
And I'm firmly in the camp that this text is a shield. It is, I think, a masterpiece of restraint. It prioritizes the subjective element. It demands that for a crime to exist, there must be a guilty mind, mens rea. You cannot accidentally commit a war crime. The system is rigged, and I think rightfully so, to presume innocence until a specific, very high-bar mental state is proven.
And I think you are reading it too safely. I see this text as a pragmatic tool designed to close loopholes. It's designed to stop a warlord from standing in the dock and saying, well, I didn't think it was a crime. It constructs a framework where objective conduct, what actually happened, can override the subjective excuses of the perpetrator. It's about accountability first and foremost.
And that is the debate, isn't it? The mind versus the act. Let's get into the text.
Let's do it.
Oris, I want to lay out my position first, and it really it anchors on paragraph 2 and its reliance on Article 30 of the Rome Statute. If you are listening to this and you aren't a lawyer, Article 30 is what you'd call the default setting for mental intent at the ICC.
Right. The baseline.
Paragraph 2 says explicitly, as stated in Article 30, unless otherwise provided, a person shall be criminally responsible and liable for punishment only if the material elements are committed with intent and knowledge.
Intent and knowledge. Right. Two very heavy words.
They are. They're the firewall. The text goes on to say that if the specific definition of a crime, say murder or enslavement, doesn't list a specific mental state, it is understood that the relevant mental element, i.e. intent, knowledge, or both, set out in Article 30 applies. This tells me that the default position of the ICC is a high bar. We don't punish negligence here. We don't punish stupidity. We punish intent.
And you view that as a protective mechanism.
Against over-prosecution. Absolutely. And to back that up, just look at paragraph 8. It defines the term perpetrator, and it says the term is neutral as to guilt or innocence. It explicitly reinforces the presumption of innocence. The text is practically shouting at us. Just because we call him a perpetrator in the text, that doesn't mean he is guilty until we prove that Article 30 standard. It prevents the court from sliding into strict liability, where you are guilty just because bad things happen on your watch.
I see that, and I respect the need for a presumption of innocence. I do. But I think you're focusing on the safety features and ignoring the engine power. My argument centers on paragraph 3 and paragraph 4. These sections, I think, acknowledge that we are dealing with mass atrocities, not a shoplifting case or a traffic accident.
How so?
Well, paragraph 3 changes the game on intent. It says, existence of intent and knowledge can be inferred from relevant facts and circumstances. That is a massive expansion of power for the prosecution. We don't need a diary entry where the general writes, I intend to destroy this village. We can look at the relevant facts, the scorched earth, the pattern of targeting, the sheer scale of operations, and we can infer the mind.
Inference is a standard evidentiary tool, sure, but it doesn't replace the requirement of intent. It just changes how you prove it.
But it bridges the gap. It allows the reality on the battlefield to inform the legal judgment. And then you have paragraph 4, which I think is the most radical part of this introduction. It deals with value judgments. If a crime includes a term like inhumane or severe, paragraph 4 says the perpetrator does not need to personally have made that judgment.
We're going to argue about that one, I'm sure. It's a very distinct carve-out.
Oh, we will. Because it essentially says, it doesn't matter if you thought you were being humane. It doesn't matter if your personal moral compass is broken. If the act is objectively inhumane and you intended the act, you are liable. That strips away the I was just following my own moral code defense. It prioritizes objective reality over the accused's internal narrative.
Let's dig into that tension you just brought up, specifically regarding paragraph 2 before we get too deep into value judgments. I feel like you are glossing over how restrictive that Article 30 reference really is.
Restrictive in what way?
The text says, unless otherwise provided. That implies that exceptions are rare. The drafters could have set a lower bar. They could have said recklessness is enough, but they locked it to intent and knowledge. If I am a commander in the fog of war, and I order a strike that accidentally hits a school, that is a tragedy. But if I didn't know it was a school and I didn't intend to hit civilians, paragraph 2 protects me from being branded a war criminal.
See, I think you're stopping your reading too early. You quote unless otherwise provided, but the text continues. It says exceptions to Article 30 are indicated below.
Meaning they are closed exceptions within the elements themselves.
Not necessarily. It also references applicable law under its relevant provisions. This text isn't a sealed box. It's a living framework. By acknowledging that there are exceptions based on the statute, paragraph 2 admits that Article 30 isn't the only way to establish guilt. The general introduction is careful not to strangle the court's ability to prosecute. If the statute allows for a lower form of intent for a specific crime, like command responsibility, where you should have known, this text leaves that door open, It's not the rigid shield you want it to be. It yields to the statute.
It yields, yes, but only when explicitly told to. The presumption remains intent. But let's pivot to your point about paragraph 4 and value judgments. You called it a radical tool for prosecution. I would call it a dangerous disconnect from the concept of criminal guilt.
Dangerous. How is it dangerous to say that a torturer can't decide for himself what is inhumane?
Let's look at the language closely. Paragraph 4 says, regarding terms like inhumane or severe, it is not necessary that the perpetrator personally completed a particular value judgment. Now think about that. To be guilty of a crime, usually you need to understand the nature of your act. If a perpetrator genuinely believes, perhaps due to brainwashing, extreme cultural indoctrination, or just the madness of war, that their treatment of prisoners is strict but necessary security, and they do not view it as inhumane, paragraph 4 says, we don't care.
Exactly, and we shouldn't care. That is the whole point.
But if they don't perceive the inhumanity, do they possess the criminal intent? If we convict them based on an objective standard, meaning any reasonable person would find this severe, we are punishing them for having a broken moral compass, not necessarily for a criminal intent to violate the law. We are getting very close to punishing someone for being wrong rather than being criminal.
But we're talking about international humanitarian law here. There has to be a baseline of objective morality. If we allowed every war criminal to define severity or inhumanity based on their own twisted worldview, we would never convict anyone. The Nazi leadership thought their actions were necessary for the state. They didn't view them as crimes in the moment. They thought they were solving a problem.
That is historically true, yes.
Paragraph 4 is the safeguard against that moral relativism. It says, you need to know the facts. You need to know you are beating a prisoner. You need to know you are depriving them of food. That is the knowledge required by paragraph 2. But whether that deprivation counts as inhumane, that is for the court to decide, not the criminal. It stops the defense of, I didn't think it was that bad. It forces the perpetrator to be judged by the standards of humanity, not the standards of their militia.
I see the utility and I understand why a prosecutor loves it, but it makes me uneasy. It's moving us toward an objective liability where the accused's actual state of mind regarding the gravity of the crime is just irrelevant. It assumes a universal morality that the accused might legitimately not share or understand. But let's look at how this plays out in the structure of the crimes themselves. This is where paragraph 7 comes in.
Right? It explains the layout: conduct, consequences, circumstances.
Right, and it seems like a formatting note, like instructions on how to read a menu, but it's actually a logic gate. Paragraph 7 breaks every crime down. 7a says crimes focus on conduct, consequences, and circumstances. 7b says the mental element is listed after each of these, and 7c lists contextual circumstances last.
Okay, why is that significant to you? It seems bureaucratic.
Because it demands precision. You cannot just have a general intent to be a bad actor. You need a mental link to each stage. You need intent for the conduct, the act of shooting. You need intent or knowledge for the consequence, that people will die. And you need knowledge of the circumstance, that they are civilians. It segments the crime. If you have the intent for the conduct, the shooting, but lack the knowledge of the circumstance that they are civilians, the chain breaks. You aren't guilty. It forces the prosecution to prove the mind at every single step of the crime.
That's a very clean, a very surgical way to look at it. It appeals to the desire for order. But paragraph 9 throws a grenade into your clean structure.
Paragraph 9.
Yes. A particular conduct may constitute one or more crimes.
Well, that's just a statement of fact. If I blow up a building, I might be destroying property and also killing people.
No, it's more than that. It's a statement of legal strategy. It implies that a single act, one pull of a lever, one signature on an order, can spiral into multiple different liabilities. You might have one specific intent, say attack that building, but that single conduct could satisfy the elements for destruction of property, attacking civilians, and maybe a crime against humanity if it's part of a widespread attack.
But you would still need to prove the elements for each separate crime. You don't get a buy one, get two free deal on convictions.
You would need to prove them, yes. But paragraph 9 suggests the system is designed to stack. It isn't trying to isolate the one true crime. It's trying to capture the full blast radius of the action. The rigorous structure you see in paragraph 7 isn't there to limit the prosecution. It's there to help them categorize the fallout. It suggests that if your intent was malicious, the law will find every possible bucket to catch your conduct. It maximizes liability.
I have to disagree that it's about stacking. I think it's about accuracy. But let's go back to this idea of capturing the blast radius versus the specific intent. You rely so heavily on paragraph 3, the idea that we can infer intent from facts.
It is essential for modern justice. Without it, unless we find a signed confession, everyone walks free.
But it is also incredibly risky. Paragraph 3 allows the existence of intent and knowledge to be inferred from relevant facts and circumstances. My concern is hindsight bias. We look at a massacre. The outcome is horrific. The bodies are there. It is just so easy for a court to look at the bodies and say, the commander must have known. I mean, how could he not?
Because usually they did know.
But must have known is often a mask for should have known. And should have known is negligence, not intent. By allowing inference from circumstances, the text is dangerously close to letting negligence sneak in through the back door. You are convicting someone because they failed to stop a tragedy or failed to predict it, not because they intended it.
I come at this from a completely different angle. I don't see paragraph 3 as a trap. I see it as the only bridge to reality, especially when we talk about command responsibility. This is where we have to talk about that Latin phrase in paragraph 8.
Mutatis mutandis.
Mutatis mutandis. It sounds like a spell from Harry Potter, but it just means with the necessary changes. Paragraph 8 says that these elements of crimes apply, mutatis mutandis, to those whose criminal responsibility falls under Article 25, and critically, Article 28.
And Article 28 is command responsibility. The liability of the superior for the acts of the subordinate.
Exactly. So look at the chain here. Paragraph 8 says, apply these rules to commanders. Paragraph 3 says, you can infer intent from the facts.
I see where you're going with this. You're combining them.
It's a powerful pathway. We don't need a smoking gun. We don't need a signed order to commit genocide. We can look at the contextual circumstances mentioned in paragraph 7c. If there is a widespread atmosphere of terror and a pattern of troops behaving brutally, we use paragraph 3 to infer that the commander had the requisite knowledge.
You are using the text to construct a web to catch the leadership.
I am. It closes the loop. It prevents the leader from washing their hands while the soldiers do the dirty work. The text is designed to catch the architect, not just the bricklayer. If the architect builds a machine that kills, we infer he intended it to kill.
But that inference effectively puts the architect in a position where they are liable for every brick laid, even the ones they didn't order. You are describing a system where a commander is presumed guilty simply because of the atmosphere on the ground. That violates the neutrality principle of paragraph 8 that I mentioned earlier.
Not presumed guilty, but held accountable for the reality they oversee. If you create a context of violence, you own the violence.
And that is where I pull back to paragraph 6. It says the requirement of unlawfulness is generally not specified in the elements of crimes. The text simplifies the elements. It strips away the need to prove unlawfulness at every step because it assumes we are operating in a framework of international law. But by stripping that away, it places a huge burden on the mental element, Article 30, to be the check against injustice. If we dilute Article 30 with broad inferences and command presumptions, we lose the protection. We end up punishing people for the chaos of war, not for their specific criminal choices.
Or we streamline the process so we don't get bogged down in technicalities about what is lawful when we are staring at a massacre. The law has to work in the real world, not just in a classroom.
We've covered a lot of ground, and I think the listener can see why this general introduction isn't just a preamble. It's the battleground. It is where the philosophy of the court really lives.
It really is. Every word we discussed, inference, value judgment, structure, that translates into freedom or imprisonment for the people standing trial.
To wrap up my perspective, I look at this document and I see a system struggling to maintain the presumption of innocence in the face of horrific acts. Paragraph 2 sets the default at intent and knowledge. Paragraph 8 explicitly reminds us the perpetrator is neutral. These are the brakes. They are there to ensure that the ICC does not become a court of strict liability, where bad outcomes equal criminal guilt. The mind of the accused must be proven. We cannot sacrifice the rights of the defendant on the altar of a conviction rate.
And I see a system striving to establish the reality of guilt in a complex world. The inclusion of paragraph 4, which tells us your personal value judgments don't matter, and paragraph 3, which allows us to infer intent from the mess of reality, reveals the document's true nature. It is pragmatic. It prioritizes the objective reality of the suffering caused over the subjective rationalizations of the criminal. It says, we know what you did, even if you lie to yourself about it.
It is a sophisticated balance. It's trying to be fair to the accused while being just to the victims.
And it leaves the judges with the hardest job in the world, weighing the psychological state of one person against the objective reality of a crime scene.
Which is exactly why these elements of crimes exist, to give them a map through that moral minefield.
A map that is still being drawn, case by case.
Thank you for joining us on the debate. We will see you next time.